Hello everyone and welcome back. In this video, I'm going to educate you on the three types of detention that we see. So, not my usual surroundings. In fact, I'm going to just show you where I am. My wife and I are actually on the Queen Mary 2. We are going from the south of England all the way back to New York. This is a trip we planned for a year, and it really is sort of the reward for helping lots and lots of people this year. And it also gives us some time away, but I never stop thinking about the work we do. So in this video, as I mentioned, I'm going to educate you about the three types of detention that we see. And we're dealing with the criminal system, we're dealing with the Baker Act, and we're dealing with Marchman Act. So obviously criminal and Baker Act are where the state has basically taken custody of somebody. The criminal system obviously is a state system. The mental health system is through the Baker Act. So if you get arrested in the state of Florida, if you are taken into custody, in other words, taken to the county jail, the sheriff has a list of bonds, meaning that if, depending on the offense, you can post a certain monetary amount, or you can use a bail bondsman, and they'll release you. Typically takes them, 4, 5, 6 hours to process you, and off you go. Unless it's a non-bondable offense, something like domestic violence, no bond on a domestic violence case, or just say that you couldn't post the bond, in which case that you're going to see a judge within 24 hours. It's called first appearance, and built into our criminal system is automatic due process, which means the judge is going to decide if there was probable cause to arrest you, was it legal. They're going to address the right to counsel. At least initially, the court's probably going to appoint the public defender just to give you some initial counsel. And then they're going to address what are reasonable conditions of release. Should we reduce the monetary bond? Should there be some kind of no contact order? But on the criminal system, you get an automatic right to due process. In the mental health system, the Baker Act, as I've sort of waxed poetic, the initial detention, if it's involuntary, because remember we have two Baker Acts, voluntary and involuntary. Again, if you're involuntary, you've somehow been detained by the state of Florida in the mental health system. And this is where things get tricky, because unlike in a criminal case where the case is automatically going through the court system, that's not necessarily true with the mental health system. In fact, you get Baker Acted and nobody actually knows you're there. And that's why it's so easy to abuse it, because if nobody knows you're there, and by the way, you can't sue them for this because they're an agent of the state, even if they're private, they get to enjoy sovereign immunity. So it's very difficult, if not close to impossible, to sue these guys and really, hit them where it hurts, in the pocket. So the initial detention, unlike in a criminal case where you're going to get to see a judge within 24 hours, is 72 hours if it's involuntary. And after that, one of three things can happen. They let you go. They somehow coerce you into signing to be voluntary, in which case your detention then becomes indefinite. No judge, no lawyer, none of that stuff. Or they petition the court for an order for extended detention, which means sometime between the time of filing and the time you get a hearing, there's going to be potentially up to another 5 days. So you can go 3 days plus 5, 8 days, no due process, none of that stuff. Marchman Act. Let's talk about Marchman Act. So the initial hold under the Marchman Act, which is now very much like the Baker Act in the terms of the way it can be initiated, but also the hold. Again, the assessment period is up to 72 hours. Unless, of course, the receiving facility thinks you need additional time for detox, or there's medical issues that need to be addressed, in which case it can go from 72 hours up to 10 days. But typically, the Marchman Act is initiated after a judge has reviewed a petition to have you assessed. And in a video I just put out, I just talked about the other two ways you can get Marchman Acted, but as a general rule, it's going to be a judge that issues a court order to have you assessed. And then there's going to be a further hearing, a second hearing, known as a treatment services hearing. That's going to take place within 10 days. So the timelines are compressed, but that's when you're going to get your due process. That's when you'll have a hearing, you'll see the judge or a general magistrate, and the court will address your right to counsel. So those are the time frames. And I know it sounds crazy, but actually, in terms of if due process and getting a hearing is the most important thing, crazy as it sounds, you're actually better off to get arrested. Maybe not for your long-term future, but I think the whole due process thing is a little bit backwards, right? You get more due process if you've done or you've been alleged to have committed a crime, and you get less due process if you've done nothing wrong, but someone says you either have a substance use disorder or a mental illness. So those are the three types of detentions that we see, and having spent about 20 years of my 32 years in practice in the criminal system as both a prosecutor and defense lawyer, I sort of understand how these things work. And of course, people with substance use and mental health disorders tend to get arrested. So understanding how the criminal system, the Marchman Act, guardianship, which is another really important piece of the puzzle, and Baker Act all work together, that's key and critical to being able to address all the issues we typically see in the kinds of cases that we work on. So anyway, from the Queen Mary to somewhere between England and New York, I appreciate you tuning in, and I'll see you in the next video. Bye-bye.